Hi, Steve Hansen with Hansen IP Law. Hey, today I want to answer a question that seems to be coming up a lot lately, and that is, if you're interested in getting a patent, where do you start? Seems like I'm seeing that question an awful lot, so I thought I'd make this video to describe the process or a way of going about it. So if you're thinking of getting a patent, you've come up with an idea and you think it might be worth protecting, the first thing to realize is you should not disclose your invention to anyone until you have some sort of patent application on file. Don't publicly disclose it, don't write about it, don't publish it, don't put it on the internet. You want to keep it secret, because if you do any of those things before you have an application on file, you actually could create a bar for yourself that will prohibit you from actually getting a patent. Now, I know this presents some difficulty for some people because often they want to go to third parties to get them to invest so that they get the resources to pursue a patent application. But if you do that, you're in danger of that other person taking your idea and getting their own patent on it, or possibly, like I said, creating some sort of public disclosure that will bar you from getting a patent. So if at all possible, do not disclose it to anyone, and certainly don't disclose it publicly. Now, that being said, the first question you need to ask yourself is what you have come up with new. In order to get a patent, something has to be novel, and it has to be non-obvious. Novel means that there's no single piece of prior art that discloses the invention. Non-obvious means that if a person of ordinary skill in the art were sitting with all the prior art around him or her, he or she would not have been led by teachings in the prior art or by design incentives known to people skilled in the art to combine or modify the prior art to come up with what you came up with. Basically, it means that that something is not novel, but it's a small change relative to what is known, and it's not worth protecting with patents. So something has to be novel and non-obvious. Now, how do you figure that out? Well, the way that you typically do that is to conduct what we call a prior art search, or a patentability search as it's more commonly known. And usually that would involve retaining an attorney or at least a prior art searcher to look in various databases to see if there are published patents or patent applications that disclose your invention. You can do searching on your own. There are a number of good, fairly comprehensive, publicly available databases, but you need to know how to do it. And if you're not that skilled with it, it can be difficult. Also, one mistake people routinely make when they're considering the question about whether their invention is sufficiently new is to assume that because they have not seen the invention in the marketplace, that it is not publicly known. That's a bad assumption. There are many instances in which an invention is disclosed in a patent or in a published patent application, but never reaches the marketplace for any number of reasons. So you should not assume that just because you haven't seen your invention in the stores, that there is not prior art out there that would block you from getting a patent. So really, a first step is to doing this is to have some idea about whether your invention is new. Now, what often happens in a prior art search is that you don't usually learn that your invention is completely unpatentable or that it's completely unheard of. Often what happens is you find out that your invention is somewhat narrower than you thought. Parts of it are known, parts of it are unknown, and what you do is you get a more refined idea of what is new about what you have come up with. And that's very helpful if you do go forward with getting a patent, because it makes the process much more efficient if you know what is new. It's also very important to know what's new and to have that intelligence from a prior art search, because the next step is to make the economic decision about whether it's worth going forward to getting a patent. Now, if you only want to get a patent for cosmetic reasons or marketing reasons, then it's not so important to weigh the economic factors, because pretty much any old patent will do. You just want to say, I got a patent on this thing, and hang it on the wall, and that's fine. But most people want to get patents because they want to make some money, which means they either want to produce the product and prevent other people from producing the same thing, or they want to license the patent to somebody else. So then you have to make a decision about whether it's worth going forward, whether what you might get out of the licensing or commercialization process is worth it. And the most important question to ask yourself is what is new also commercially valuable? I'll say it again. The question you want to ask is whether what is new is also commercially valuable. Whatever patent you get will be no broader than what is new. And again, I'm using the word new as a shorthand for the legal terms novel and non-obvious. Okay, but your patent cannot be broader than what's new. So the question is that new piece worth money? And there are two key components to that question. The first is, can competitors avoid using that new feature and still keep their market share? You know, if a competitor can continue to sell their product without your new features and maintain their market share, then it may not be worth much. The second question is can you detect infringement? In other words, you know, when someone's making a product, you can go buy the product off the shelf and you can determine certain features about the product. But if you can't tell from the product whether somebody is actually using your invention, then it may not be a good candidate for patent protection, because you're never going to be able to know whether somebody is infringing your patent. The only way you would know that is if you had internal information from the company. Now, how does this come up? Well, it comes up mostly when the invention you're talking about is a process invention that has to do with the method of making the product. Now, sometimes a method of making a product leaves a fingerprint in the product, and you can tell from the product that the method was used. But many times that's not the case, and the product itself reveals nothing about whether the process was used. If that's your invention, you may be better off keeping it as a trade secret and exploiting the economic advantage that you get from knowing that secret and not disseminating it to anybody. That may be much more preferable to getting a patent. But at any rate, that's the key question you want to ask. Is the thing that's new also commercially valuable? So if it is, and if you have some idea now about what is new about it, in other words, what's novel and non-obvious, then the next step is to go forward with the preparation of a patent application. Now, if you're new to the process, one thing you have to understand is that a patent application is not merely filling out a few forms, although there are some forms involved. A patent application is a detailed document that describes to people skilled in the art how to make and use the invention, and which includes a number of claims that define the scope of what is protected. It's not something that an amateur or a novice can skillfully do just by getting a book from the bookstore on patents. All right? There's a lot of skill involved, in particular in drafting claims. So you really want to find a patent attorney that you're comfortable with, who you can work with, who is well versed enough in the technology to do a good job, and you know, we can discuss later how to select a good patent attorney, but you're going to want to find a good patent attorney. Now, let's go back to that chicken and egg problem I talked about at the beginning. If you don't have the resources to hire a patent attorney and you need to get investors involved, you kind of have a dilemma, right? You can't get the patent attorney because you don't have the money, and you don't want to go to the investors until you have a patent application on file. If that is your situation, you can file a provisional patent application, at least in the United States. The filing fee is only like $125 if you're a small entity, just an individual, or you have a company with fewer than 500 employees. And you don't have to have patent claims in it, and you don't even have to have formal drawings. Now, a provisional patent application ultimately is only as good as what you disclose in it. And I talk about that in another video. I don't want to go into that here. So the point is that when you draft it, you're going to want to describe the invention as thoroughly as you can, keeping in mind that you want to teach people skilled in the art how to make and use the invention, and keeping in mind that you want to clearly and thoroughly describe those features that you determined were new, again, novel and non-obvious, from your patent search. Once you file that provisional patent application, you'll have a year in which to file a non-provisional patent application, which is the one that will actually be examined. Your provisional will not be examined. It's the non-provisional that gets examined. And during that year, you now will have the opportunity to go seek out investors so that you can get the funds together to file the non-provisional patent application. Okay, but really this is sort of the ideal sequence of events in most cases if you want to think about getting a patent. Okay, so hopefully that explains the process a little bit. Until next time, I'm Steve Hansen with Hansen IP Law.